of times what our clients ask us is, so like, how is it that he's back home? Right? How is it that I'm still, icing my face, and like can't move my neck and he's back home? How is this possible? Right? And we don't have a good answer for them, right? So what I'm saying is that I think that you need to have a balance.
The discovery law is extremely demanding, and that's not a bad thing. I think we would all agree that the discovery law should be demanding. The challenge is that the sanction, the penalty for not complying with this very demanding statute is often dismissal of the case. And we're not perfect. We do our very best, but sometimes something might not get turned over, sometimes through no fault at all of ours, and that means that the case gets dismissed.
I believe in open and full discovery. I was a prosecutor at the beginning of my career, and I always felt I want to provide everything possible so that there can be a resolution, or if there's a trial, that the defense can be fully informed. I think what's happened now since the reforms, there has been a kind of artificial and in some respects arbitrary way of sanctioning a prosecutor when there have been discovery violations. Certainly anything that is intentional, prejudicial, overt, has to have a certain kind of sanction. On the other hand, small, late discovery, not as relevant documents, there can be a incremental sanction. What's happened is it's tied to speedy trial and cases get dismissed. Our clients, when they hear that, they are witnessing a criminal case. They don't really understand why the case has been dismissed. They go to family court, and that hurts their family court case as well. They also don't have the benefit of a order of protection from the criminal courts anymore. And it does, what we're hearing from our lawyers here, it does have a negative impact on the civil litigation in the family court.
I think that the purposes of family court and criminal court are very, very different. And some of our clients want justice. And they want for there to be some level of accountability for their abuser. And also it could be that we just don't have the resources that exist when there's a criminal case, right? So there are no warrants in the same regard. There's no bail in the same regard in family court. The protections are just less. And sometimes what ends up happening, just because of the nature of how things are right now with discovery, is that we're kind of forced to tell our clients not to file anything and to stay out of family court. Because again, family court will drag them into this whole proceeding.
We had a rape case recently that was dismissed because a detective had been texting with the survivor, which is very common, about coming in to meet. Because as you can imagine, during the investigation, detectives have to meet with survivors. And so they had texted back and forth about what days they were available, and they had come up with the certain dates that the survivor came in to meet with him. And so the vast majority of the text messages between the detective and the survivor were about that. They were about what date she could come in to meet with him. There was one text where she had mentioned something that was relevant to the case. One. And the detective, thinking or maybe even misremembering that all of those texts were about scheduling, didn't immediately turn that over to us, and so we didn't turn it over to the defense. We found it later, and we did turn it over. And as a result of that missing text message, the case was dismissed. a rape case where a survivor will never see justice for having been raped because one detective forgot about one text message and it was turned over, and the case wasn't even scheduled for trial. And so that's the problem with the discovery statute. It's not that it's demanding. We agree the discovery law should be demanding. Those text messages should be turned over. And there should be a sanction for the fact that that message wasn't turned over. No one disagrees with that. But dismissal, that black and white case is over. Survivor never sees justice because of one text message. That doesn't make sense, and it doesn't feel fair. And when we then have to explain that to survivors, they don't understand.
I think it's also an incredibly demoralizing moment for our clients because a lot of times, obviously these are civilians. They don't necessarily know the law. They don't know how strong or weak their case is when they're speaking their truth. But sometimes they can tell because they're like, I have my neighbor, I have the video, I have the photos, I have the medical records, so they can't possibly comprehend how this case is not getting prosecuted. And it's also very disheartening, I'm sure, for the ADAs to have to pass this information, and I'm sure that this became a big part of their day. So we came in and we sort of closed this hole that we weren't really meant to close. That I think that was not the legislative intent, is for family court to step in and cover these cases that are perfectly provable and triable in the criminal context. That was not the intent.
Anytime you make a major change in a law or practice, it comes with some growing pains. And I think that's what's happened here, that it was like a blunt instrument was put to the discovery statutes without a real understanding of the nuances involved. And I think it's a much more nuanced way of handling discovery to support and pass the governor's bill.